distinction needs to be understood. Because if I tell you that this is the way you can do something, that is just an introduction to what you are doing. The nitty-gritty of whatever you are doing in regard of that area requires either your knowledge, your research, or legal advice. And I am starting from the various ways you can either come to the UK or regularize your stay in the UK. I know we have students who are on Tier 4 and workers who are on Tier 2. I don't know if we have ministers of religion who are also on Tier 2. Yeah. Now, I will apologize to you that I'm not going to give you the breakdown of what your route is going to be, but to introduce you to it. Because every little mistake you make on those routes will cost you thousands of pounds to amend. So you have to be very careful that you don't say, that old man Olorunfemi told me I should do A, B, C, D. I am introducing you and enlightening you on how you can go about it. So the people who are on certificate of sponsorship or people using cars, you know yourself, all the Tier 4 students are on cars. All the workers are on COS. You know yourself. You need to be careful because all your applications are timed. And when you miss those times, you are in big doo-doo. So please be careful. You can't put your blame on me. So I will go through the stages, the routes that which you can come. And I'm going to start from family route. On my note, I know I have the family route. But there are recent changes in the family route which you need to familiarize yourself with. In the past, if you have your husband or your wife in the UK, and that husband or wife in the UK is either settled or has become British or has limited leave to remain. Please, I'm not talking about all the people on I'm not talking about skilled migrants now, and I'm not talking about students. I'm talking about people who have leave to remain, either settled, limited, or who are British citizens. The way to bring your family to the UK, please listen carefully, there are changes now. It used to be that your income threshold will be 18,600. That is to say, if you are bringing your wife or your husband, you need to have a regular income, an annual income of at least 18,600. You need to have an accommodation. You need to be able to establish that you have been in regular contact with the family you are trying to bring to the UK. And you need to establish that relationship with documents, with communications. Now, the money has gone up to 29,000. So there is a transitional gap. I don't know which of you is within that gap. When you need to show 18,600 as the financial requirement, the first child takes your income threshold to 22,400. So it goes on and on. So there is an incremental value on your income depending on the number of children you are bringing. With the rules that have come into effect now, it's a plus and minus, to some people plus, to some people minus. You now need to hit 29,000 per annum income. However, the breakdown of child 1, 2, 3, and 4 is removed. So that's a relief as a plus for people who have many children, who will probably need to earn 32,000 something in the past to be able to bring all the children. Now, under this transition, if you came to the UK under the 18,600 annual income rule, and you are bringing your family, your new threshold remains the previous threshold. However, they will still cap it for you at 29. So please hear this properly. You are following the old route, but the advantage for you is when you actually need to hit 29 and above. So when you need to hit 29 and above, the recent changes pegs it to 29. That's what you are looking for. So now the people you want to bring are limited to your wife and children. It used to be that you can bring your mother and your father. In recent years, those changes meant that you can't really, as a right, bring those people anymore. It used to be that when they clock 65 and above, you can bring them. That is gone now. So if you came to the UK under the very old rules, be careful when you do your applications that the new rules now have brought in new changes. Now, your parents now are the rules, the way they are interpreting it in the Home Office is now they are considered as adult dependent relatives. So you need to be careful. There is a fee for each adult dependent relative. There is a little twist in how you evidence you are able to take care of them, because you need to show that they will not depend on public funds. So they will calculate what your total income is to see whether that adult dependent relative, you can cater for them when they come. There is a visa fee for that is over £3,000 per person. Now, on that one as well, I need to remind you that people here who are renewing their papers, because I got an inquiry not so long ago where a lady had been advised that because she was on 2.5 years leave to remain, she could not bring her son. Thank God that son is in the UK now. So be careful when you get your advice. Anything that is not clear to you, seek further advice. The problem with us Nigerians is we want free advice everywhere we go. If you don't pay for your advice, you will get advice, but that advice will not be useful. Because no lawyer wants to sit down endlessly giving you free advice. They pay their professional indemnity insurance, all the insurance, all the subscriptions, they pay from the money they make from you. Just like you make money from other people who are paying for other things. It's the way the world goes round. So go to where they will actually give you advice of the whole process. Pay. Because then the advice they give you, you can tie them down to it. Now, for the people who are on 2.5 years, you can still bring your wife. I'm not talking about skilled workers. Skilled workers, you can no longer bring your dependents, unfortunately. But people who have 2.5 years in the UK, and people have been advising you that you cannot bring your family because of whatever they are telling you, I'm giving you practical example that we just brought our client's own child to the UK. So you just need to watch the evidence and make sure that the requirements are met in the application that you are submitting. Now, for people who came as spouse to the UK, when you came as spouse to the UK, you are on a 5 years route. Now, on a 5 years route, you have to meet the financial income requirement and, of course, the English language requirement you all know is standard. Sometimes when you are doing the extension of that application, your salary dips and you can no longer meet the salary requirement. If you cannot meet the salary requirement, you are dropping off the spouse route into the family route. And we're dealing with family route now, but the family route we're talking about is the 10 years family route. Now that 10 years family route means that you pay more money. Let's look at it carefully. When you are on the 5 years route, you only renew one time. The next time you are doing your application for indefinite leave to remain, you avoid IHS fees. Or if you don't meet all the requirements when you are renewing and they grant you on the 10 years route, imagine how much money now that you need to be paying every time you are renewing on the 10 years route. However, if at the time they send you to the 10 years route, you then subsequently meet the requirements of the spouse route, you can put in another application or wait for an extension and meet all the requirements. At this time, your application will not be on the 10 years route. You will do an extension on the spouse route, which is called further leave to remain on the basis of marriage. That will then bring you back to the 5 years route. However, you have lost 2.5 years. Because on that 10 years route, on that 5 years route, you have to start all over again. So it is important for you to monitor your qualifying criteria when you are on the 5 years route, so you don't find yourself on the 10 years route. I've had inquiries about people who have been sent on the 10 years route and they want to struggle to go back on the 5 years route. But if they go back on the 5 years route or stay on the 10 years route, there is no numerical year advantage, because they are probably on it for 7.5 years. So why struggle to go back to meet 10 years route when you are going to start all over? You don't gain any advantage. So stay on the 10 years route, because on the 10 years route, if you don't have sufficient income and you can show that you haven't got the income to pay for the application and the IHS fees, you can apply for waiver. On the spouse route, there's no waiver. You're on your own. You need to meet the relevant income threshold. That is for people bringing family either on the spouse route or on the 10 years route. Now, before I go, there is another one that I separated as private life route. I'll explain that to you. It's not per se family, it's a private life route. But the way you get to that, if you have been in the UK for 20 years and you haven't got papers, the rule allows you to apply for leave to remain on the basis that you've been in the UK for 10 years, for 20 years. Please note it. It is not 10 years. 10 years is often confused with the 20 years. 10 years is lawful residence of 10 years. 20 years is a combination of both. If you are applying on the 10 years route, at the end of the 10 years, you are applying for indefinite leave to remain. If you are applying on the 20 years route, at the end of that, you are only applying to start a 10 years journey. So please note the difference. So when you are legally present for 10 continuous years, your application for indefinite leave to remain, as long as you meet other requirements, will succeed. But if you're on the 20 years route, the success of your application is a start of a 10 years journey to settlement, if the rules don't change before you get there. So now for the private life route, there is another one. If you have been in the UK, a mixture of lawful and unlawful residents, as long as you are not in prison, because time in prison is not counted towards your continuous residence, it will break it. And you've got children who have been in the UK for 7 years, that used to be a concession in the past, is now under the rules. It's been under the rules for a few years ago now. So you can apply on the basis of your child that has been in the UK for 7 years. You can apply for further leave to remain. That, if you succeed in that application, you are on a 10 years route. If you have been in the UK and you are under the age of 25 and you've spent at least 2/3 of your life in the UK and you still don't have paper, you can also apply under private life. So under that private life, people who've been for 20 years, people who've got children, and the children have been 7 years, and people who've been in the UK under the age of 25 but have spent 2/3 of their life in the UK. Those ones can also apply under those rules. Before I leave family, I will go to the children of the family. If you have children here that were born in the UK and they've been in the UK for 10 continuous years, you can make an application to register them. So imagine if you have 4 children and they qualify to be registered as British and you don't register them, and now you want to apply for indefinite leave to remain. Multiply the fee for each child and your child and see how much you pay when you want to do indefinite leave. So it pays you, it gives you advantage to register them after 10 years and they drop off your application for indefinite leave, because the fee for them is 1,214. But when you want to do your indefinite leave, it's over 3,000. So you get that advantage by registering them after 10 years of being born in the UK. Now, what about those who were brought to the UK? Were not born in the UK, but they were brought to the UK, but they have been in the UK for 10 years, and they are still under the age of 18. Their application is not straightforward, but you can apply as well to register them. The application you will submit for the one who was born here and has lived for 10 years is different. The application you will submit for the person that was born abroad and brought to the UK and has lived in the UK for 10 years is different. It is a more complex application process for the one who was brought in, because the Home Office will always say, your parents don't have settlement. When we return your parents, it is in your best interest to go with your parents. So they always have a way to refuse them. So you have to work hard to put all the documents properly through with that type of application. Please Don't forget that individuals who are advising you in the community are advising you on their experience. So somebody who registered his 10-year-old child is telling you it is straightforward, but your own child was brought in. So 10 years, but different routes. So please, don't get yourself misled when you are preparing that application. All right. That is covered. If you have any questions on that, I'll answer them or I'll go forward. Do you have any questions in relation to that? That is, a vast majority of us can fall into this category that I explained. That is why I started from it. I'm going to go to some other ones that are restricted to people with tier 1, tier 2, tier 4. And then I will go to asylum. So if you have any questions regarding this, not a legal advice, ask the question, please. Yes, mommy. Hallelujah, mommy. Yes, ma'am.
For somebody who has been in this country for over 10 years and has not regularized their papers, and they don't have any child or any spouse, which way or what can they do? Do they have to wait for 20 years? Is anything possible for them?
Thank you, mommy. Please sit down, ma. Thank you for your question, mommy. The straightforward answer to mommy's question is no. They have no hope for anything. Rules are rules. We are live, we are online. You can ask me other questions later on, mommy. Rules are rules. If you don't fit into any of those rules, then you need to analyze your condition, because that person that has been in the UK for 10 years over, with a mixture of lawful and unlawful residence, if that person is seriously ill, if that person has an illness that is life-threatening or an illness that is terminal, with a lot of medical reports and expert reports, please get it right, medical reports from your doctor, from your GP, from your health counselors and all the rest, plus an expert medical report who will assess all the reports from the GP and the hospital and give an opinion as to whether your removal from the UK will shorten your life. If that report is conclusive, non-judgmental, independent, and free, that is, they don't make a decision on the credibility of what you said, they make a decision on their own assessment of their interview with you and the papers you submit. You can use that to apply to the Home Office for discretionary leave to remain. Now, the Home Office always has a way of throwing that out. They say, you have, which country? They mentioned the country. You have functioning healthcare system, you have functioning police, you have functioning court system, you have support left, right, and center. They would tell you 1 million support things that are present in your country. What they are not bothered about is the accessibility that you have to that, and whether, other than writing it on the paper, those facilities actually exist. So, the next report, if you have money, you might take, is for a country expert report. Please listen to me carefully, because the reports, you might think they are getting duplicated, they are not. They are not getting duplicated. They serve different purposes. The stronger the evidence you present, the more difficult is it to refuse you. And if they refuse you, the easier is it for you to convince a judge going forward. Now, the country expert report will be able to say all this list of prescriptions that you have, they don't have it in your country, or it is too expensive in your country, or where they will have it will be hundreds and hundreds of miles. That country expert will be able to confirm that. So now you have two different expert reports. They're not contradictory, and they are not duplication. Please don't let us argue like people who are not resourceful to understand how evidence works in the Home Office. The expert medical report is saying that those medications, if they withdraw you from it, it will lead to your life being shortened and give other effects of those medications and the reason why they should not remove you. The country expert report is saying that all those medications they listed in your report are not obtainable in your country. So they're saying the same thing at the end of it in different ways. One is analyzing the treatment you are receiving and the continuity of that treatment. One is analyzing the availability of your treatment and your medication in your country. Now, mommy, it is still your question that I'm answering. You see how long the short question you asked me? So that one, you need a lot of expert advice in order to follow the evidence properly. You have to always remember that if you give wishy-washy evidence to the Home Office, you will not have a chance to succeed on appeal because they will throw it out. But if you give good evidence to the Home Office and they either make errors of law in interpreting or the assessment of your evidence, a judge who is an independent person, different from the Home Office, they will have a look at your evidence, and if you meet the requirement, they will overturn the decision of the Home Office. That means that all the evidence you are preparing at the beginning, you are preparing it with a foresight that if these people at this level refuse me, what will be the assessment of the people higher than them? So I have to put all the evidence to them. So, mommy, your simple question is not simple at all. Any more questions? I will go to the work route. This is a very delicate one, and I will repeat as I go through work route that I am not giving you legal advice. Because if you use a certificate of sponsorship with one place of work, and that place of work's certificate of sponsorship has been withdrawn, you are in trouble. Don't forget that your employer is giving regular updates to the Home Office. Don't think there's confidentiality when it has to do with you, with your type of visa. They're giving feedback to the Home Office all the time. So if the employer that gives you a sponsorship certificate loses their right to sponsor, that is, they lose theirs, because it's from their own sponsorship license that they issue you your certificate of sponsorship. If they lose that sponsorship certificate, you are in trouble because you have limited time to then look for another job with another person that has got sponsorship certificate. That is why you have to seek advice and pray at all times. That is why you have to do the Jerimuyama in and out, because God is seeing your problem before it becomes a problem. Okay, this is not a legal advice. We are in the church and need to let you know that everything in the hands of God is possible. Because where others are failing with your situation, you are succeeding. And they think you have a godfather. No, you have the God that is the godfather of all godfathers. So, you need to be careful. And for students, now, before I go to students, now I told you that you can no longer bring your dependents. So, because you are on 5 years route, if you can't bring your family at that time, you can do two things. You can make your husband or your wife also come on a sponsorship certificate to come to the UK. All right? So you are on a sponsorship and she is on a sponsorship. Whichever one of you gets to indefinite leave to remain first will bring the remaining family. Because it doesn't mean that because you start first, you will get there first. It just depends. So you can do that. Another thing regarding that is that at all times, you need to watch the qualifying criteria for your route. Because on that route, if you have to change employer, you will not be able to rely on, oh, I've been working. There's somewhere in the road that says you've been here for 12 months. Please, don't lay your eggs all in that basket, because it depends on who is assessing your application. So try always to make sure you meet the requirements of the rules in whatever route you find yourself. Study route, I've covered that. Work route, I've covered that. Investment route. Now, the investment route is one that requires a lot of money. Before, if you have 50,000 in bonds, and you can trace, you can show that you can transfer that 50,000 bonds to the UK, you'll be able to apply for a visa to do that. So little by little, they've taken all of those routes out from our hands. So you need a lot of money, and that one is you will be eligible for an investor visa if you have enough money, entrepreneur visa. But this requires a significant financial outlay. That's why I'm not writing off any of us here. But from experience, how many people can put down £1 million easily from their pocket? In the past, if you have 250,000 or 200,000 and you invest, you can apply. But they've changed all of those things as to global talent. Everything is changing in relation to investment. So I'm not going to give you any advice on that. If you find yourself there, please seek legal advice to make sure you don't just spend money for the lawyer and for the Home Office for nothing. The lawyer will take his own money. The Home Office will take their own money. None of them refundable. So make inquiries. Not many of our people come through the investment route. So I'm covering the routes that are common to many of us. I go to one that is very, very common, and that is the asylum protection route. Please listen to this, because many of us have claimed asylum in the past or currently in the asylum system. For the people who are in the asylum process, there is a common error. The first time you phone the Home Office that you want to claim asylum, your story has started. When they invite you for the first contact interview, everything you say at the first contact interview is part of your story. And many of us get it wrong from that moment. And we need to be careful. Many people don't know that they have protection issues. But if they tell their story and a lawyer is hearing the story, the lawyer will be able to tell them they have protection needs. Unfortunately, people don't take advice, so they are not able to pick out their protection needs when they go to that first contact interview. They don't give the protection information. And the information you give at the first contact interview, which is called screening interview, is the foundation of your asylum claim. So if you go there and you don't raise any protection issue, your asylum is already failing before you start. So please seek advice. Before you make the phone call to say, I want to claim asylum, discuss with a lawyer what your story is, so that if there is asylum or protection need in your story, they will tell you, these are your protection needs. If you go to your first contact interview, tell them what your protection needs are. And many of us have failed because of that. Some people have come and they go to the first interview and say, my parents were forcing me to sleep with an older man. What has that got to do with protection? Report to the police. This is real life. It's not story. Some people have come to say, my father married many wives. One of the wives of my father is harassing me, beating me, cursing me. So I ran away for my safety. That's got nothing to do with asylum. But those are the things you are recording in the Home Office papers. Some of them said they want to circumcise me. That's why I ran away. But you are no longer a child. And they did not circumcise you for 18 years. And you are bringing circumcision claim to the Home Office. Circumcision claim is a claim that you can put forward for protection if properly evidenced. Don't get me wrong. Because there are 5 categories in asylum claim that you can fit your story in. And one of them is belonging to a particular social group. Now, if your story is about circumcision, look at your story, look at what you are claiming it about. Look at the fact that you can move, if you are under 18, yes, you can play that. They will always say you can move from, for example, London to Newcastle if you think that your family will force you to circumcise, or the tradition of your family means that they have to circumcise you. Although it fits into the head belonging to a particular social group, the fact that you have an internal relocation option means that you can move to another part of that country. Think carefully before you go to your first contact interview. There are some people whose claim are political. But generally in this country, Nigerian men, for example, it will be difficult for you to get asylum because they believe that Nigerian men are so enterprising that if they face danger in one part, they are off to another part. So they don't believe Nigerian men need asylum protection here. So in order for you to be one of the few that will get it, your evidence must be very cogent. Your evidence must be properly sourced. You need to prove that you have a well-founded fear of persecution on the basis of what you experience in Nigeria, either on, or in your country, either on grounds of religion, political opinion, ethnicity, or belonging to a particular social group, or the 5 aids you need to at least show one of them. So before you go to that first contact interview, identify which one you belong to and provide evidence of the one you belong to. These are for the initial asylum claimants. Always try to get legal advice before you go. Please don't look for free advice. Free advice don't often give you what you need. But, we are live, and I'm telling you this for free, because if I don't have free advice in my work, and you insist you need free advice, you will get the free advice without getting the substance of what will help your application, because I am also paying different organizations to get that knowledge. We are subscribers to different bodies of people to get that knowledge. So if somebody is telling you that you need to get that knowledge for free, just tell them back that it doesn't work like that. I can't go to pizza shop and collect pizza and say because the tomato is not the right one, I'm not going to pay. So you go to the place you want to buy things with your money to buy exactly what you want to buy without excuses. I've dealt with long residence. So sorry, I need to talk about fresh claims. Aha. I see many people putting fresh claims in everywhere. The test, the legal test for fresh claim is different from the initial asylum claim. The initial asylum claim, you have identified that you need protection, you have provided evidence of the protection needs, and you have presented everything to the Home Office. But now, the Home Office says, we don't believe that you have a well-founded fear of persecution in your country. So we refuse your asylum claim. And then, down the line, you come across evidence which shows that your life continues to be in danger in your country. Now, putting that evidence together at this time is different from your initial claim because there is a test. That evidence you have now got, when considered with the evidence that you have previously submitted, they must have a realistic prospect of succeeding. It's a test. Get a lawyer's advice to review your new evidence, review your old claim to see whether your fresh claim will meet the relevant test. Now, one other thing you need to understand about that is whatever credibility findings they've made against you in your initial asylum claim, those credibility findings are present permanently on your file. So when you have your new evidence and you want to make your fresh claim, the starting point is to address all the credibility issues in your previous claim. I say all the credibility issues. Please don't fall into the error of blaming people who've worked on those cases. All the problem, everything is on your doorstep. You are yourself to blame. You have to take responsibility. You have to explain all the credibility issues the judge found against you in the court. You have to try as much as possible to rebut all those findings of adverse credibility by, if they say, well, we don't believe you are from Nigeria, then look for your Nigerian passport or your ID card or anything that ties you to your country and say, okay, Judge, you are wrong here. This is my passport. Now, you now need to answer the next question. If this passport was available at the beginning of your claim, why did you not produce it? So before they ask you that as a weakness in your fresh claim, you have to explain it. That this passport, although I had it at that time, but it was lost, or it was somewhere, you need to explain why you did not make it available because it's not a document that was not in existence at the time that you made your initial claim. So any document that is in existence at the time you made your initial claim that you are now using for your fresh claim, you need to explain why you did not present it with the initial claim. Seek advice. Now, after you've dealt with all the credibility issues in the previous claim, you now want to compare those answers with the new evidence to make sure that the new evidence does not contradict what you have said. There has to be consistency in everything you lay before the Home Office, because they play more on your inconsistency than on your real evidence. We are live, so I need to say what I am aware of. And I'm aware that they often play more on the little things, the inconsistencies, than the real evidence itself. And that is why you have to prepare your roads to the court, because they are independent and they will look at everything holistically in order to make a decision. So be careful when you are doing fresh claim. Now, that is fresh claim asylum. You can also have a different situation where your application under the family route was refused, but now one of your children has become 7. You can re-put in your application. Before I leave asylum claim, there is a current battle ongoing about the plan of the UK government to send people to Rwanda. Now, the noise is about people who are coming by boat, and the campaign is Stop the Boat. So, in effect, the United Kingdom is shifting the responsibility of assessing the asylum of the people who come by boat to Rwanda. Now, if any of you receive a letter that you are getting sent to Rwanda, you need to seek advice. Not so long ago, the Supreme Court said the law as it is being interpreted currently was wrong, and that move was stopped, but the government then found a way round by going through the parliament to lay the law before the parliament so that it is out of the judge's hand, it will be in the statute book. But last week, it got to the House of Lords, and the House of Lords are not happy with certain aspects of it. Be aware that when governments set out to do something, they will find one way or the other to accomplish it. So be careful if you receive such letters, seek legal advice without failing. Now, I say people coming by boat, and I say the campaign, stop the boat. Don't forget that once the government succeeds in one step, the second step will not be obvious to you. And by the time you know it, it will be everybody claiming asylum that will be getting on the way to Rwanda. So be watchful and watch every letter you receive from the Home Office. And then from there you seek further advice. I think I've covered all that is for the routes through which you can either come or regularize your stay in the UK. The things that I've not mentioned are victims of trafficking or slave labor and victims of domestic violence. The law has changed to favor victims of domestic violence a little more now, but you need specific advice. But if Now, in the past, or in the recent past, if your husband brings you to the UK, or your wife brings you to the UK, and he becomes your Lord and Master, and start to terrorize you, beat you up, throw you out, punch you for every little thing, please erase the African mentality that if I report my husband, the family will fight me. If I report my wife, the family will fight me. That is African mentality you need to get out of your system. Because your children you think you are hanging around in your husband's house for, they will leave when the husband kills you. So if you are a victim, or you think you are a victim of domestic violence, have no fear. Have a record of what you're suffering. Such domestic violence is not limited to punching you. Financial restriction, movement restriction, what's other that? Psychological warfare. Everything that has to do with your emotion is still part of domestic violence. You just need to make sure you clarify all those things, and you need to seek help. Now the law as it is now, the changes in the rules has favored and has expanded that. It used to be people who come with spouse visa that can enjoy that. But now, you students, beware. If your husband brings you on a student visa, the past, you don't have a claim for domestic violence. You can now if you are getting maltreated. So also for men, which is not usual. But if you are suffering domestic violence and you came as student, your wife or your husband can have a claim, unlike before, that they have to have come with a spouse visa. Beware of that. And they will give them leave to remain for 3 months, and then they will find their way. They will be able to know which application they want to make after that time. That's available to you. For victims of trafficking, the United Kingdom is very hot on the people trafficking or slave labor. There are people who have been brought to the UK under one pretext of a visa or the other. And once they arrive in the UK, they collect their passports. They are now using them for prostitution. They are using them for labor here and there without payment. If you think you fall into the category of a victim of slavery, raise alarm. But be careful before you raise that alarm to the first responder. The first responder is the person that you speak to that will then bring your matter before the national referral mechanism, where they will see whether there is a suspicion that you are a victim or you are being trafficked. Seek advice before you go. I think I've more or less covered all of those areas. If you have questions, please go on. Yes, sir.
At what age can we bring our parents to the country to stay with us? If we are a British or other states, I don't know.
All right, thank you, sir. But, there is no route for you to bring your parents by right. You have to apply to bring them under adult dependent relatives. And that does not matter what age they are. It just matters that you can prove that they absolutely or almost absolutely depend on you. And then you have to meet the financial requirements. Seek advice. Mommy.
People come to us for advice. I've had people come to me and say, Mommy, you can sign this for me. They said you can sign this.